Welcome to 5 Dubs by MDDC Press. I'm your host, Rebecca Snyder, the Executive Director of the Maryland, Delaware, and DC Press Association, which represents news media in our region. 5 Dubs focuses on the who, what, when, where, and why of local news media. We'll talk with the journalists about the stories behind the news. You can find more information about our guests in the show notes or on our website, www.5-dubs.com. Welcome to Max Mishkin of Ballard Spahr. We're here today to talk about anti-SLAPP and some legislation that's moving forward through the Maryland General Assembly. So welcome, Max.
Thank you for having me.
So anti-SLAPP, before we get into the mechanics of the bill and what it does, let's talk about what it is, what a SLAPP suit is. And I will freely admit, this took me a little while to understand. And when I say a little while, like, I feel like I'm still cultivating the nuances of SLAPP versus libel versus defamation. So tell us, from the attorney point of view, what's a SLAPP suit?
Sure. So SLAPP is an acronym. It stands for a strategic lawsuit or strategic litigation against public participation. The classic, which is to say, without the acronym, it is a lawsuit whose purpose is not necessarily to win the lawsuit, but to use the expense and annoyance and invasiveness of litigation to silence somebody whose speech is, antithetical to yours or who is competing with yours, and to chill them into not speaking as much in the future. It's so the lawsuit is, plaintiffs often want to win the lawsuit, but winning is not the sole motivation. It's the bringing the lawsuit itself, and the pain and expense of the lawsuit is part of the goal. Sorry, I hear the garbage truck outside beeping. Everybody's wondering what that is.
Well, that just proves this is real life for you.
Exactly. So, SLAPP suits tend to be libel lawsuits, but they don't have to be. So, libel or defamation, somebody has written something, in order for it to be give rise to a claim for defamation, the speech needs to be false. It needs to be a statement of fact, not an expression of opinion. It needs to be about the plaintiff, sufficiently identifiable of the plaintiff. It can't be about a large group of which the plaintiff is just a member. And it has to be made with, the minimum required level of fault, which is for private figures in many states negligence, and for public figures everywhere is what's known as actual malice or constitutional malice, i.e. you have to know what you are saying is false or have subjective doubt that what you're saying is false as you're making it. Actual malice is another confusing term along with anti-SLAPP, where it doesn't have anything to do with malice as we normally understand the term. It's not about whether you have ill will or you mean to harm. It's really knowledge of falsity.
Interesting. Okay.
But that is to say, defamation lawsuits are the most common kind of SLAPP suits. But you could bring, for instance, an invasion of privacy claim. Could be a SLAPP suit, depending on, again, if it arises out of speech on a matter of public concern, and if sort of the purpose is to, silence somebody whose speech you don't like. That, very commonly we see, invasion of privacy claims being asserted in a context where the media defense bar would feel comfortable asserting an anti-SLAPP, filing an anti-SLAPP motion against the lawsuit.
So then really it's kind of, if I'm thinking through this, it's the SLAPP suits are sort of like a type. They're like an umbrella. They can cover a lot of different, there can be a lot of different components, whether it's, defamation, whether it's libel, whether it's invasion of privacy, but it's not, it's more that the reason the suit was brought is what makes it a SLAPP suit, as opposed to the elements of it. Am I getting that right?
Yeah, that's right. So there is no, there is no claim in the law like that. I am filing a SLAPP suit. No, plaintiffs wouldn't, in the way that, you have to style your claim. This is a defamation suit. This is a invasion of privacy suit. This is a, claim for assault and battery. It is a broad, like I like the term umbrella. It is an umbrella descriptor of, any type of civil suit that is designed to have this, chilling effect on speech.
Oh, that makes sense. And so, as this is the podcast for the Press Association, we really talk a lot about journalism here, but SLAPP suits, I think, go far beyond just journalists, although they can have really chilling effects on news gathering operations and severe financial effects on news operations and the business of the newspaper. But what in working on this issue, I have talked to just private citizens who are speaking out about real estate development in their areas. I've talked to environmental advocates who have been slapped. Talking more and more increasingly to survivors of domestic abuse, where their abusers are manipulating the legal system. And so you have, as an attorney who works in these areas, what are you kind of seeing? Is there a quintessential SLAPP victim, or are you seeing it from all areas?
Sure. Well, anyone can be the victim of a SLAPP suit. I'll say that, or should be, I would say, the target of a SLAPP suit. It is certainly true that sort of the traditional initial view of a classic SLAPP lawsuit is, a neighborhood group of, people skeptical of a nearby development, who are, speaking out at the town meeting about zoning approval, and the developer, like a 1980s movie villain, looking to develop the local, ski mountain, or build in the local swamp or wetlands, files a lawsuit against the community members speaking out, who are opposing the development, not because necessarily they believe that their reputation has been injured, but because, at least not that they sincerely believe that, but because they know that being the subject of a libel lawsuit might cause people to stop speaking out, and will cause other people not to speak out at all. So, and you will see that there are some SLAPP laws, and I should say that SLAPP laws are currently state laws, and so many states have SLAPP laws, and they look different from state to state. A recent development is sort of the push for a uniform SLAPP law, and we can talk about that. Mm-hmm. But generally speaking, SLAPP laws vary state to state, and some states still have SLAPP laws that are sort of very narrowly designed to protect people who are speaking out on, land development or environmental matters. Mm-hmm. But though that is sort of the classic model of a SLAPP lawsuit, what I see in my practice as a media defense lawyer is SLAPP suits aimed at journalists. And, whether they are, you can have a SLAPP lawsuit filed against the most well-resourced, global-reaching news organization, or, the most, local family-owned newspaper. And it's just a question of, scale. Mm-hmm. I will say that SLAPP, if you are a well-resourced and, well-lawyered and well-insured media organization, the threat of a SLAPP suit may seem less to you, though there are aspects of litigation that are uncomfortable for everyone, right? And discovery is invasive no matter who you are. And so one of the things that makes SLAPP laws valuable is that they often freeze discovery and allow the case to get decided as a matter of law before the plaintiff gets to root around in your papers and depose your journalists. And that, protects the major news organizations as much as the small news organizations and the independent journalists. But of course, the availability potentially of getting an award of your attorney fees is what really is a game changer for sort of the small news organizations, the victims of domestic violence who may have, they may not have a lawyer on call who knows how to defend a defamation suit, let alone be willing or have the means to pay, by the hour for an attorney to litigate this. Same with a nonprofit environmental group. Might pose a severe economic hardship to defend a libel suit. So one of the things that makes SLAPP laws valuable is what we call fee shifting. The American rule, as we call it, is generally that each side pays its own lawyers, win or lose, with some exceptions. And SLAPP laws often create an exception so that if a libel plaintiff brings a lawsuit that qualifies as a SLAPP suit, and you, the defendant, avail yourself of the protections of the anti-SLAPP law, and you win, you will often be able to recover, that is to say, get the court to order the plaintiff to pay you the attorney fees that you had to pay in order to defend yourself. So that really does protect. Getting your attorney fees is particularly important. Exactly, especially for the independent journalists, the victims of domestic violence speaking out, and who are being sued by their abusers, nonprofits, etc.
Well, so I'm taking back in my mind something that happened back in 2016. There were two women in Harford County that were speaking out about Harford County's land use plan legislation, and they were hit with a SLAPP suit, a $75,000 SLAPP suit, which is, as a private individual, I don't know about you, Max, I don't have $75,000 rolling around. And the thought of that being a possibility would just flip me out. And that's not even defending. And, I think even to do the minor basics, you're probably looking at $10,000, $15,000, $20,000 in legal fees. And so what actually Stephanie Flash and Beth Pajoli were the women. They testified last year about their experience in front of the legislature. And Stephanie said that she became so hesitant in her advocacy efforts. She was like, if the developer is always going to win, why would I even speak out? Why would I do that? And I think it's really, when we talk about SLAPP suits, these aren't esoteric issues about like, this person is coming in and these like innocent, citizens are having troubles. Like, it is real people with real economics, and it is unsustainable. And literally the only reason that Stephanie and Beth were able to defend themselves was that they found a pro bono attorney. The ACLU helped them in a pro bono aspect, but it was not easy. And they really thought about whether or not it was worth it. And so when you think about that chilling effect, could you talk a little bit more about how that plays out in civic life, in journalism, even in personal lives that you've seen?
Sure, and I thought that their testimony last year was very powerful. I hope they're
so compelling.
Planning to submit testimony again this term, since I think the legislators should hear from ordinary citizens who have faced these lawsuits head on, and not merely lawyers like myself who litigate them, but who don't have nearly the level of skin in the game. A chilling effect is a term of art in media law and First Amendment law, which is that like, there are lots of laws where the passage of the law is not just designed to punish the thing or stop the thing itself, but also to chill people, to make people second guess or self-censor because they don't know whether the law is going to be enforced against them in a particular manner. So this is why, when you have lawsuits challenging laws as unconstitutionally vague, especially laws that regulate speech as unconstitutionally vague, a vaguely written law that, creates penalties for certain kinds of protests. You might sue that as violating both, the First Amendment because it infringes on free speech, and also 14th Amendment due process because it's vague, and those work together to say, look, if a law is vague and it might be used against me in my speech, I'm just not going to speak, right? Because I don't want to take the risk of potentially being subject of litigation or state action. That's sort of when you talk about a chilling effect, it's normally, at least in like First Amendment laws, often used in that context, right? Like whether a law will have a chilling effect. But lawsuits also have a chilling effect. That is to say,
Right.
If an oligarch brings a lawsuit against a big newspaper, and issues a press release and hires a flashy lawyer, and gets a lot of press from the filing of the lawsuit. The oligarch may well know that filing the lawsuit doesn't just extract resources from and exact pain and annoyance on the defendant, but also gets all the other journalists out there who know about the lawsuit, who might be thinking about writing on the same topic. And
Right.
it, consciously or subconsciously, they will go through the calculation of, is it worth my time? Is it worth the risk? Maybe there's a newsworthy story here, but I don't want to get tied up in litigation for the next 3 years by writing about somebody who has maybe effectively infinite resources to bring as many libel lawsuits as they want. So I'll just find something else to write about, or maybe I'll write about it, but I won't include this detail that I probably that I think is defensible. I could include, but it's just not worth the risk. That is chilling effect or self-censorship. And
Mm-hmm.
like I said, sort of a classic purpose of a SLAPP suit is not just to punish the speech, but also to stop others from engaging in the same speech, and it's a force multiplier, right? It's effective
Mm-hmm.
to bring one lawsuit and you silence a whole bunch of speakers.
Right, sure. That is,
So,
and it's sort of making the example, it's the head on the pike to be like, this is what happens if you go against me.
exactly. And so, the possibility that a plaintiff might have to, that is especially attractive if the plaintiff knows, look, going out, either the plaintiff has infinite resources or effectively infinite resources, or it is much less expensive to be a plaintiff in a lawsuit, generally speaking, than to be a defendant. You are often not paying your lawyer by the hour. You're giving them a share of the potential recovery of damages. They might take home a third of what you recover, but maybe you're only paying costs instead of hourly expenses, whereas many defense lawyers are paid by the hour. So it's an easy economic decision to say, yeah, it doesn't. I mean, there's Donald Trump has a almost word for word this quote saying, like, it doesn't cost me, in Donald Trump famously litigious and now both subject of and bringer of defamation lawsuits, used to love filing defamation lawsuits and would say openly, it doesn't cost me much to file a lawsuit, it costs them a lot to defend it. Why wouldn't I do it? The availability of being able for the defendant to be able to recover their fees at the end of the lawsuit at least provides some second, should impose some doubt in the mind of the plaintiff. Like, it's not necessarily costless for you to file this lawsuit. You think you're going to get a chilling effect for pennies on the dollar. Well, you might actually, depending on what happens in the litigation, you may end up having to pay quite a bit for what you thought was a chilling effect.
So we'll get to the elements of the sort of ideal anti-SLAPP legislation, the SLAPP statute, in just a second. But I wanted to, because we're here because there's a bill before the Maryland legislature, and I definitely want to make sure that we're talking about how Maryland stacks up against other SLAPP statutes. But I wanted to go back. I think Donald Trump, as you said, has been, I think, has done so much to bring SLAPP suits to the forefront of discussion. But I think when I've talked to people about SLAPP suits, sometimes I hear like, oh, well, that's the liberal media, protecting themselves so they can write whatever they want. And I know in your practice, you have a wide range of clients dealing with SLAPP, but I really want to address that specific pushback of the partisan nature of SLAPP, because to me, it does not seem partisan. It seems very much an underdog. You're rooting for the person without power in that role. But what's your perspective on that?
Yeah, I think that's exactly right. I mean, and the fact that Donald Trump is a classic SLAPP plaintiff doesn't mean that SLAPP plaintiffs are conservatives and that SLAPP defendants are liberals. And anybody can be the subject of a SLAPP lawsuit, and often they have nothing to do with politics at all, right? Like the example of domestic violence survivors who were sued by the same people who victimized them. There's no political valence to that, but you will often see, conservatives can be the subject of, that is to say, can be sued for defamation, just like liberals can. I personally have defended a pair of very conservative anti-abortion filmmakers and documentarians who were being sued by a Democratic Party affiliated judge who did not like their reporting on a lawsuit that he was presiding over. And they had sufficient ties to California that they asserted the protections of the California Anti-SLAPP Act, which is one of the I think it was the first major anti-SLAPP law. The former lieutenant governor of Virginia, Justin Fairfax, sued CBS for defamation a few years ago. My firm defended CBS in that lawsuit, and I believe asserted the protections of what was then the new Virginia anti-SLAPP law. That's Justin Fairfax was a Democrat. There are Democratic politicians, Democratic judges, liberal, wealthy individuals who like to silence criticism of them, just like conservative wealthy individuals who like to silence criticism of them. So it is absolutely the case that the protections of an anti-SLAPP law are protections for speakers regardless of politics. And there's I hope that people who are considering whether an anti-SLAPP law is a good idea will take into account that anyone can find themselves sued for defamation, regardless of what party party affiliation they have on their voter registration.
Absolutely. And it is, so I want to turn now to the ideal SLAPP statute. And you mentioned that every state is different. There is no federal SLAPP statute at this point, although that seems to always build a little momentum in Congress and then fizzle out. So, blessings to Congress. We'll hope that works. But stacked up, Maryland had one of the earliest anti-SLAPP statutes on record, but it seems to have dwindled. So how does Maryland compare? So first, I want to know what's the ideal statute, and I know it certainly would involve fee shifting.
Mm-hmm.
And then how does Maryland compare to that ideal?
Sure. So I would say an ideal SLAPP law has a few main components. One of them is a nice broad definition of what kind of lawsuits, or rather what kind of speech, if it is the subject of a lawsuit, qualifies as a SLAPP lawsuit. So generally, when you're trying to figure out whether a lawsuit qualifies as a SLAPP suit, it turns on what the speech being challenged is, speech or expression or petition. And like I said, some states have very narrow definitions relating to just speech about environmental or developmental issues. But an ideal law would broadly define the speech that is capable of giving rise to a SLAPP suit as any speech made to the public or on a matter of public concern or an issue of public interest. A good law might include some examples, but I wouldn't sort of try to define the speech narrowly. Because I think speech on a matter of public concern and speech made to the public is really which should encompass also, a true act of petitioning, right? Like a speech in front of your town council, or a letter that you've a sign-on letter that you've circulated that you're going to submit to the local town executive, right? Like that should also give rise to the protections of the SLAPP law. So first, a nice expansive definition of what kind of speech counts. The second, I think, ideal thing, and I will say it's ideal, though I'm happy to talk about why it actually makes things complicated in some instances, is what I mentioned earlier, which is sort of a discovery freeze, right? So once you qualify as a SLAPP lawsuit, and you bring a motion to what we would call an anti-SLAPP motion, special motion to dismiss, motion to strike, whatever the law calls it. In many states, once a lawsuit is filed, the plaintiff can pretty much immediately start taking discovery, i.e. they can send you requests for documents, they can send you written questions you have to answer under oath, they can start noticing depositions, that is to say, force you to come and sit in front of a court reporter and answer questions under oath as if you were in a courtroom. Some states pause discovery until later, but in many states, discovery starts right away. And so a good SLAPP lawsuit will freeze discovery. It is good to allow you to recover the costs at the end, but it's better to prevent that kind of invasiveness and expense from being incurred before the plaintiff, and this is sort of the next thing, the plaintiff carries their burden of showing that the lawsuit has some merit. So expansive definition, discovery freeze. Early burden shifting would be, I would say number 3, which is to say, normally in a lawsuit at an early stage, if a defendant wants the court to throw out a lawsuit, I often like to think, when I'm describing what a lawsuit is like, I often try to describe it as like a highway with a bunch of off-ramps. And, at the end of the highway is a trial, but there are off-ramps before then. The first off-ramp is what you normally call a motion to dismiss. You would say, look, Your Honor, pretend everything that they say in their complaint is true. There are, constitutional or legal reasons, reasons as a matter of law why this lawsuit should get thrown out. For instance, like, oh yeah, I admit it. I said what they claim I said. I published it. A lot of people heard it. It made a lot of people think less of them. But what I said was, a truthful and accurate report on a matter, on a court record. So it was privileged, and you can decide that as a matter of law early and throughout the case. There are many states where it is hard to win on a motion to dismiss in an ordinary lawsuit, whether it's defamation or, like I said, a breach of contract. So one thing that good SLAPP laws do that is valuable, is shift the burden onto the plaintiff to say, hey, if you want this lawsuit to go forward, you have to convince the judge that you have a reasonable probability of prevailing, or that your lawsuit is meritorious, whatever the standard, whatever the language of choice the legislators come up with. The important thing is that the plaintiff has the burden early to say this lawsuit really has merit. This is not, and can survive as a matter of law. That burden shifting is important, and whether that requires sometimes the plaintiff might even need to sort of put evidence on the table early in a way that in many lawsuits they don't have to do until much later. It forces an early adjudication of whether the lawsuit should be able to go forward, which again, it's good to be able to recover your costs at the end of the lawsuit. It's better to stop the lawsuit from incurring those costs as early as all right, so what do we have? We've got expansive definition. We've got discovery, shifting burden. The next thing is defining the elements of defamation itself. Now, this is something that I think when people were initially coming up with SLAPP laws, it wasn't front of mind, but is now. And I'll take a very small detour in saying, as I mentioned, in defamation law, the fault that you have to show, that how at fault was the speaker when they made the speech that's being challenged. Were they negligent? Did they know what they were saying was false? And that often depends on the plaintiff's status as a private figure or a public figure or public official. And that derives from New York Times versus Sullivan, the landmark First Amendment lawsuit, where the Supreme Court said that public officials, and then expanded to public figures later, have to demonstrate actual malice in order to prevail on in a libel lawsuit. And that, because that arises from the First Amendment, every state at a minimum, if you're a public official or a public figure, you have to demonstrate actual malice. Some states have said, you know what, we want to be more speech protective than that. And states can be more speech protective. They can't be less speech protective than the First Amendment provides, but they can be more. They can say, we think all libel lawsuits, fault should be actual malice. Or in New York State, rather than simple negligence, it's what they call gross irresponsibility. SLAPP laws can, in addition to the things we've talked about so far, they can tweak the standards, the standard of fault, and say, for instance, rather than speech about a public figure or a public official requires actual malice, speech on any matter of public concern if you want to bring a lawsuit and the speech is over a matter of public concern, you have to demonstrate actual malice, even if you, the plaintiff, happen to be a private figure. If the speech is important to the public, then there should be a higher degree of fault required. Now, this is important, especially now that there have been, over the past few years, led in part by Justice Thomas, a new degree of skepticism over Times versus Sullivan. That for years and years, Times v. Sullivan was it was super precedent. It was untouchable. It was bedrock First Amendment doctrine, and all of a sudden now you're seeing some rumblings at the Supreme Court from some justices that maybe the public figure doctrine has gone too far. How do we know who's a public figure anymore? Everybody is a micro celebrity. Now, I think there was a decision last year called Counterman that had a very robust reaffirmation of Sullivan's principles. But still, if you want a belt and suspenders, if you want to make sure that even if an attack on Times v. Sullivan goes forward, that your state is still going to protect speech in the way that it ought to be protected, you can, as a matter of state law, say, look, we're going to require either public figures or public officials to demonstrate actual malice, or speech on a matter of public concern has an actual malice fault standard. That can be part of the SLAPP law. I think it's very valuable. And like I said, it's often overlooked. I think that brings us to the last element of a great SLAPP law, which is
right? It always comes down to the money, really, doesn't it, Max?
And so, there are sort of two types of fee shifting, what we call permissive fee shifting and mandatory fee shifting. Permissive is, at the end of the lawsuit, the judge can decide whether, whether under the circumstances the plaintiff ought to pay the defendant's fees. And then there's mandatory fee shifting, which is if you win you file an anti-SLAPP motion, you win, case goes away, and the plaintiff must pay you your attorney fees. And of course, with some amount of judicial oversight of what is a reasonable amount of fees. But still, the difference between, shall pay and may pay is a big difference. Exactly. And that, so we can sort of go right into where Maryland lives up to and where it doesn't on those ideals, if you want.
I do, but first, I was thinking as you were describing those 5 points, is there a unicorn state where, who has anyone implemented every part of the ideal SLAPP law? Who's close?
I don't think. I mean, California is great. People talk about California as a great anti-SLAPP law. It has its own idiosyncrasies about what counts as a SLAPP and what doesn't. But it is, I would still say, among the gold standard. And thing like things get close, but they fall, they fall away in part, right?
So nothing's perfect in the world, and that really does bring us to the Maryland law, because national organizations who track anti-SLAPP laws give Maryland a D, which is really embarrassing and sad, and just not good for the public or for public discourse. So tell us what's wrong with the law now, and then we get to talk about House Bill 330 / Senate Bill 560, brought in by Delegate Rosenberg and Senator Hedelman. Tell us what's wrong with Maryland first, and then we'll talk about the new bill.
So, starting with what qualifies as a SLAPP, Maryland's current law falls short in that it has a standard that I think was at the time considered normal, but has since fallen by the wayside, which is in order to qualify as a SLAPP lawsuit, the lawsuit must have been, quote, brought in bad faith. As opposed to, what I would say a model SLAPP lawsuit isn't asking about the subjective intention of the plaintiff. It's merely asking, does this arise out of speech on a matter of public concern? Maryland's law says, no, it has to be brought in bad faith against a party who has communicated with a federal, state, or local government body or the public at large to report on, comment on, etc., in any way exercise rights under the First Amendment.
Do you think that's why there's so many? I just want to interrupt and ask, do you think that's why there's so few suits identified as SLAPP suits because the standard is so high, it's almost an impossibly high standard. How can you prove bad faith?
Yeah, bad faith is very difficult to demonstrate, and frankly, it's especially difficult to demonstrate early in a lawsuit. And so, where you want a SLAPP suit to be the most, a SLAPP motion, a SLAPP law to be the most robust, is early in the lawsuit, right? But just like plaintiffs will often say, well, how do you expect me to demonstrate actual malice before I've gotten discovery? I don't know what these reporters were thinking.
Yeah.
It is you will have SLAPP defendants say, well, how do you expect me to demonstrate bad faith before I've taken the deposition of the plaintiff, before I've gotten their records, find out what they were saying, behind closed doors about this lawsuit? It's difficult. It's difficult to show early that a lawsuit was brought in bad faith, and so if you can't even do that, that threshold, this counts as a SLAPP early. The lawsuit, the legislation is
You're
less
kind of dead in the
practically
water.
important. Exactly. Now, I will say that the Maryland Intermediate Appellate Court in recent years has a nice opinion about being able to identify bad faith on the face of a lawsuit. That itself is sort of a unicorn of a ruling. It's until there have been many years of this suit and many courts saying that you can't possibly find bad faith just on a complaint alone. So I don't want to say it can't be done. It can be done. But it is certainly a lot harder to secure the protections of a SLAPP law if you have to demonstrate that the plaintiff is acting in bad faith. So that's, again, sort of what the current law departs significantly from what we would consider best practices. The next thing that I think that the current Maryland law has a concern about is, or I would have a concern about in terms of comparing it to what we would consider best practices, is there's no current discovery freeze, right? It's just you can bring these lawsuits, as I understand it, that does not entitle you to ask the court to, hey, any discovery needs to pause until you have adjudicated this motion to dismiss, or the special motion to dismiss. So that, again, is difficult. And then fee shifting, there's no mandatory fee shifting in Maryland, even if you could qualify as a SLAPP suit early, and even if you could satisfy the standard. You get to the end of the day, the judge might still say, nope, you're not getting fees. And then, what really was the value of the additional defenses to you, and what really is the deterrent effect of the law to the plaintiff.
So it feels like that's not a very protective statute. You have to demonstrate bad faith early on when it's really difficult to understand what's going on. So you have to pay for all the discovery. You have to kind of go through all the motions. You don't have a quick exit ramp.
Mm-hmm.
You don't have the shifting the burden earlier. You don't have the tweaking the standard of default, and you don't have the shifting of the fees. Like, Max, is there anything good about the Maryland law? I'm now you're rocking my foundations a little bit.
Well,
anything redeemable?
It is. Look, I'm not gonna say it. A D is better than an F, right? It is better
All
than
right.
a law that says.
Tell that to my parents.
D's get degrees, C's get degrees. I think Pennsylvania's law, another outdated one that one of my colleagues at Ballard Spahr, Mike Berry, is working very hard to update. Also, has this very narrow definition of speech arising from relating to development or environmental issues, right? It's better than that. It is better than something that is so limited as to essentially write out a lot of the speech that we are interested. Whether you're talking about the press or whether you're talking about survivors of domestic violence, right? Neither of those are necessarily talking about a local fracking proposal.
Right.
So I don't want to say it has no merit, but it is outdated. It is missing the tools that make a modern anti-SLAPP law useful. And that is a fixable problem. That is something that the Maryland legislature could remedy.
Okay, so let's get down to brass tacks because the Maryland legislature has an opportunity, which I will say they've had the opportunity for several years running. We've been really fortunate to have Delegate Sandy Rosenberg of Baltimore City bring this bill forward year after year. This year it's House Bill 330. It's cross-filed in the Senate by Baltimore County's own Shelley Heddleman, Senator Heddleman. And so this is a bill. It's also the House side is hearing it February 7th. I believe the Senate is hearing it on February 20th. So there's still certainly time for people to reach out to their legislators on this. What does this bill do? How does it fix the sort of like broken mess that we have in the current statute?
Sure. So this, this bill would make a lot of improvements to the current state of the Maryland anti-SLAPP law. It wouldn't move it to the head of the class, but it would put it in, in the cohort of useful.
Are we in C or B territory with this bill?
It's hard to say how the law would shake out until you see it in practice, right?
Okay.
Because sometimes provisions that you think are going to be great end up not being as useful, and sometimes things that you don't think about nearly as much. For instance, I think legislators didn't necessarily realize how important the changing the fault standard would be when they were doing that prior to the attack on Times v. Sullivan, right? So hard to forecast for sure how useful a law is going to be in advance, but it will certainly make Maryland much more speech protective. And would do that in a few ways. So it would get rid of the bad faith requirement and replace it with a more expansive and sort of traditional definition that a SLAPP law must arise from speech on a matter of public concern, or made in a public place, or made as part of an exercise of speech or petitioning. So that first standard would be what we're looking for in a SLAPP law. It would shift the burden onto the plaintiff to show that the SLAPP suit has a, quote, substantial justification in law and fact. Now, again, as I pointed out, a lot of states have a lot of different formulations about what standard the plaintiff has to show, whether they have a reasonable probability of prevailing, whether they are, forecast a likelihood of success, right? That's going to shake out to what, how courts interpret it, and what in practice they decide would be a substantial justification, law and fact. I think it's a standard that has teeth, though, and that's important. Whether it's identical to another state standard or not, it's definitely an improvement, because the plaintiff should have to show early that, for instance, they're bringing a lawsuit over speech that is a statement of fact, right? If they're bringing a lawsuit over speech that's an opinion that once the court sits down and adjudicates, no, this is protected by the First Amendment, the lawsuit cannot prevail as a matter of law. Forcing the plaintiff early to show that it has a substantial basis would be a major improvement. Discovery is presumptively stayed while the court is adjudicating that motion. It allows the court the language would be, if it appears likely that discovery will enable the plaintiff to defeat a motion to dismiss, and that discovery will not be unduly burdensome, the court may order that discovery be conducted. So it pre-butts, it addresses the concern that a lot of libel plaintiffs bring, that, well, how can you stay discovery? Then I won't be able, I couldn't possibly make the showing if I don't have discovery. This is no. But you've got to make the case to the judge. You don't get discovery by right from the start. You have to explain what it is you're looking for, why you think it's going to help you survive this motion, and an order allowing discovery shall be conditioned on the plaintiff paying any expenses incurred by the defendant in responding to the discovery. So again, it's not a free chilling effect. Oh, well, I'm going to send off a bunch of discovery requests. It doesn't cost me a lot to write them. It costs them a lot to review a bunch of documents and decide what to produce. If you're going to impose costly, burdensome discovery, you have to do that knowing that you're going to pay the bill at the end of the day. So it's
those three main points then. So it's the broadening of the definition, getting rid of that bad faith. It's refining that early look so that you have those off ramps. but the choices always seem to still reside with the judge. There's no automatic, issues. It's the judge gets to decide. Do you take that off ramp? And then finally, it's the fee shifting. So those I think are the three main points.
And also it imposes the constitutional malice requirement. Let me pull up the actual text.
And so I also am this feels to me that if there's a legitimate libel or defamation case, that's not going to be able to go through any of those off ramps, because you can still bring those suits are still very much. You can certainly bring those kinds of suits. Is that your thought as well?
That's right. It doesn't make these lawsuits go away. It's not a silver bullet. The lawyers hate this one weird trick that makes libel lawsuits go away. Like it is not a magic trick. It is not tipping the scale over. It is merely, I would say, sort of balancing the scale to allow what is currently in asymmetric in favor of libel plaintiffs who can impose costs and bring these lawsuits cheaply and easily. And often, within the absence of SLAPP lawsuits, survive early motions to dismiss and take a case pretty far, depending on where they are. It balances it much more than it tips the scale in favor of defendants, and certainly does not. It is not a magic suit of armor for speakers to say what they want without fear of being sued.
But it does allow those people who are unempowered or vulnerable within their community economically or socially to have some protections.
Exactly.
And that I think is, again, I kind of think about it's rooting for the underdog. And so as we wind up, because I feel like I've bent your ear about anti-SLAPP forever, and I really appreciate the time that you've taken. What do you, where would you sort of land? Like, do you think these are really necessary protections and changes to the SLAPP law? And does this bill fix the problems? Does this make the change that we need? Is it enough?
Yeah, and so there were sort of two more points I wanted to make about the current bill. I can make them here, which is one.
Go for it. Sorry.
It does impose a constitutional malice requirement. I was right about that. And it does have, what I would say is very good, though not perfect, fee shifting. It's a funny written phrase where it says, if the court grants an anti-SLAPP motion, the court shall award costs and reasonable attorney's fees. So you would think that's mandatory, not permissive, but it says shall award if the court determines that justice and equity require it. So it's shallow. It's mandatory, but permissive.
Shall, not a...
Now, again, we'll see how courts, if it's passed, we'll see how courts shake it out. I think that's better. I think that having a shall phrase in there is good. It indicates that the legislature wants there to be fee shifting. It's better than just may award fees. It's not as good as must award fees, but it's very good. And so, yeah, I think with those 2 points, based on what I was saying before, this would be a huge improvement to the state of the law in Maryland. It would make a significant difference, especially for, again, the smaller news organizations that aren't as well-resourced, well-lawyered, and well-insured. It would make a huge difference for the community activists who want to speak out and might be afraid to do so because, they've read about libel lawsuits. They've read about, they've seen a movie, they know what a deposition looks like. They don't want to be deposed. And, ordinary citizens who just want to speak out about the difficulties they have faced in their life. We ought to be giving them the tools to do that. And the anti-SLAPP law it's just that. It is a tool that helps speakers to speak out on matters of public concern. Like I said, it is not a, get out of lawsuit free card. It is not a say what you want without consequences card. But it is, it would be a big difference to my clients and to many people who aren't my clients, who are just looking to contribute to public discourse in exactly the way that the First Amendment and the Maryland Declaration sort of expects and hopes that citizens will engage in speech.
Absolutely. Max, thank you so much for lending your really strong lawyer brain to this issue and step by step helping us go through it and understand what can be a complicated issue. I mean, I think it boils down to very straightforward, issues of right and wrong. And I'm so appreciative to have your thoughts and opinions on the matter. So we will see how this session turns out. I'm really hopeful that these set of bills will make it over the finish line, and I'm sure we'll talk more about it when it happens.
I hope
but
so
thanks
too.
so much for coming.
Thank you for having me. It's a real pleasure.
Woo! Thanks for listening to 5 Dubs with Rebecca Snyder. Please subscribe and leave us a 5-star review wherever you download your podcasts so that others can find us. What do you want to know about local journalism? Email me at rsnyder, SNYDER, @mddcpress.com. Interested in supporting our podcast and journalism? Please donate to our 501c3 Press Foundation. Find out more and see the full episode list and show notes at www.5-dubs.com.